Hello viewers, welcome to my YouTube channel. There has been rumor that after divorce, properties are shared between husband and wife on a 50-50 basis. The properties are shared equally between husband and wife. How true is this position under the law? That is what we are going to be looking at in this video. To answer this question, we are going to look at section 72 and section 73 of the Matrimonial Causes Act. We are also going to be looking at judicial authorities, that is, decided cases by the courts to answer this question. Section 72 makes adequate provision for settlement of property, that is, how properties are to be shared and distributed after divorce. From section 72, there are following points to note. Number one, the property to be settled must be a property that is owned by one or both spouses. Two, the property to be settled must be real or personal property. Three, property can be settled for the benefit of one or both spouses and the children of the marriage that are less than 21 years. 4. The decision of the court when it comes to settlement of property must be just and equitable. So you can see from that section that section does not say property must be shared equally. It said the decision of the court must be just and equitable. So now let us proceed to decided cases to see how the courts have settled issues that relates to settlement of property after divorce. In Essien and Essien, the court held that for a party to succeed in an action for settlement of property, such a person must be able to prove joint ownership or financial contribution, because under the law permits women to own their own property by virtue of Married Women Property Act 1882 and the various married women property law of different states. So women are allowed to have their own separate properties, same as husband too can have their own separate property. So for you to be entitled to settlement of property, for you to say, oh, this property belongs to us, you must prove joint ownership, or you must be able to prove that you contribute to that property, financial contribution. That is what the court held in Essien and Essien. The same decision was reached by the Supreme Court in Amadi and Nwosu. And Supreme Court says that where you bring an action for settlement of property and you cannot establish joint ownership or financial contribution, that your action will not succeed. It must fail. Now you want to ask me, what happens where the woman cannot prove financial contribution or joint ownership? Is she going to go empty-handed? The courts answered that question in Doherty and Doherty. In Doherty and Doherty, the woman was unable to establish joint ownership or financial contribution, but the court, in a bid to do justice and equity, decides to give the woman 3-bedroom flats out of the properties of the husband to cater for her basic needs. Now you can see. Another point to mention is that settlement of property does not envisage transfer of ownership. It does not mean that once properties are settled by the court that ownership is transferred to another spouse. No. Because by virtue of section 73, subsection 1J of the Matrimonial Causes Act, that section allows for an order for settlement of property to be discharged, to be varied, to be revived, and all. So that section provides that where a woman in whose favor an order for settlement of property was made remarries, that order will be discharged. So ownership in the property is not transferred when it comes to settlement of property. It is only for the spouse to enjoy that property and use it by the reading of section 73 subsection 1J of the Matrimonial Causes Act. But there are instances where the court can decide that make a payment to this spouse or make a payment to this woman. That was held in Shodikpe and Shodikpe. In Shodikpe and Shodikpe, the court valued the property of the man and the property worth 10 million naira. 10 million naira. The woman was unable to prove joint ownership of financial contribution, but the court, in a bid to do justice and equity, ordered that out of the 10 million that the property worth, 200,000 naira should be paid to the woman, and 200,000 naira was paid to that woman. She spent 43 years in the marriage. You may want to say, but this is kind of harsh, is an injustice. The courts, at times, depending on the arguments of the lawyers, always lean on the part of equity, and this was the decision of the courts in Ogonoye and Ogonoye. In those cases, the court held that even where the woman has not made direct financial contribution, her indirect contribution must be considered, and in that case, the court settled the property in the favor of the woman. The same decision was reached in Muela and Muela. The same decision was also reached in Okala and Okala. So, properties are not shared on 50-50 basis in Nigeria by virtue of section 72 and section 73 of the Matrimonial Causes Act and the cases we have examined. Properties are not shared 50-50, and the man can also go to the courts for property to be settled in his favor. It is not only for women, as we have seen. If you find this video useful, please do well to share with your family and friends, subscribe, and drop your comments.